The world is changing faster than ever before. In the past 10 years, there has been an exponential technological evolution, the kind of technology that has revolutionized the world of work as we know it.
The Lawyers Hub was founded on the principle that law needs to interact more with technology, and that greatly affects tech policy as well as access to justice. So the Lawyers Hub exists as a confluence between law and technology, working on tech policy, on emerging technologies, as well as increasing and upskilling the knowledge of lawyers in the area of technology. We support tech startups as well to ensure that the tech ecosystem also engages in policy, but as well understand the issues around data protection, issues that also concern their structure, as well as intellectual property.
If you look at the evolution of technology, it's been relegated as an alternative in most systems. But the realization that the 21st century has brought us into is that technology has to be an integral part of our day-to-day systems. And if you look at some critical technology areas like artificial intelligence, blockchain, nanotechnology, biotechnology, then it gives us a strong indication that if we do not start having discussions on the use of these technology areas, as far as law is concerned, then we may be in some kind of trouble. So Lawyers Hub is leading the debate on the use of these technologies, especially in Africa.
Over the years, the Lawyers Hub has supported the innovation ecosystem, convened events such as the Africa Law Tech Festival and the Global Legal Hackathon. The Lawyers Hub has also supported government innovations within the justice sector, as well as trained government institutions and more than 10,000 lawyers across Africa on emerging tech policy.
Our dream at the Lawyers Hub is to have open access to law. We envision a continent where there is access to justice through leveraging technology and with a crowd of enlightened lawyers. We see a continent that also protects its own through better tech policies, that emerging technologies, through its regulation, will offer better value and consumer protection for the people within Kenya and within the African continent. We envision that we will convene policy makers, regulators, as well as lawyers who are more enlightened on emerging technologies and with better digital skills. And we invite you to be a part of this great vision for Kenya and for Africa. Good afternoon and welcome to the Lawyers Hub. Thank you very much for joining us this afternoon as we discuss the data protection regulations today on Monday at 2 p.m. Thanks for joining us. And we want to invite you to engage with us today. It's a really, interesting discussion on data protection. And I have to start from all protocols observed. We have in our midst today the Data Protection Commissioner, the Data Commissioner, as well as the PS ICT. And so I hope that I am quite in order to observe that particular protocol. We also have with us the task force that has come together to put the regulations. I'm going to have my colleague introduce them after we are done. But I want to invite all of you to join us at this discussion. There's a chat section, and I want to invite you to put your comment. Let us know where you're joining in from, what organization you are representing. If you're comfortable enough to let us know which organization you're representing, we'll be happy to have that feedback because of public participation around data protection regulation. If you have a question, do not put it in the chat. Use the Q&A tab. That will help us to track the questions that we'll be answering at the end. We'll also be able to give you an opportunity to ask an audio question. If you want to be unmuted so that we're able to ask a question, please feel free to raise your hand at the tail end of this particular session, and we'll be able to take your question. I want to acknowledge some people in the room. We have DJ Coman. He's saying greetings from Nairobi. This is DJ from Power Internet. Thanks for joining us. Claire Davan, she's connecting from Washington, DC as a consultant for the World Bank. Thank you very much for joining us today. We have Salma from TESPOC, the IT technology providers. We have Dr. Isaac Rutenberg from Strathmore University, that's CPIT, they work on law and technology, and Francis Kamui from MultiChoice Kenya. Thanks for joining us. We have Stephen, who is a South Sudanese lawyer, joining from Sussex in the UK. We have Nyabuto, sorry, I can't keep up. We have Laura Kerubo from ATC. We have Peak Vision from the UK. We have someone joining from Tanzania, Paul Kaunda. Thank you so much for joining us. If I skip your name, please forgive me, but there's so much. And everyone joining us on the chat, thank you so much for typing in there. Please interact on the chat and let us know where you're coming in from. I'm impressed that there's David Munyendo from the Christian Blind Mission, Kenya. Thank you for joining us. And we also have Wanjiku Mwai from Oxygen. And we also have Kevin Mugo from Secunets Technologies, Mabati Rolling Mills. Thanks, Anthony. I can't see the lawyers. Okay, Malcolm Kijira, who's a lawyer, thanks for joining us. Joe Githaiga from PwC, thank you very much for joining us as well. Sorry if I don't read your name. Frank from Google, thanks for joining us as well. Liz Lenjo, MYIP Legal, thank you so much for joining us. The People Daily, Adalia, and I will give up on reading the chat because it's too much. Thank you so much for joining us. But we just want to know what sector you are from. And so we're going to do a fast poll question. So what word best describes you? Are you a legal practitioner, a tech enthusiast, media, government, academia, or other? Please just vote. That will take less than 20 seconds and we'll wrap up the poll. Thank you very much. I think we will close the poll in another 5 seconds just because of time. What word best describes you? Are you a legal practitioner, a tech, media, government, academia, or other? So half of us have voted, 65% have voted. If you give it a few seconds, please vote. And I think we wrap it up. That's a good sample size. We wrap it up now. Okay, 65% of you legal professionals, tech 13%, media 1%, government 7%, academia 4%, and others is 11%. I don't know who we didn't represent, but let us know. Maybe civil society as well. Let us know. We go to our second poll question, and this is going to be wrapped up in another 1 minute. So our second question to you: do you think, and this is in your estimation, is your organization data protection compliant? Please note that this is anonymous, and so you don't have to worry about the repercussions, but is your organization data protection compliant? You can say yes, no, or I don't know. Then we give it another 5 seconds. If you're on Twitter or Facebook, please follow ODPC_KE. That's the Twitter handle for the Data Commissioner. Also, Lawyers Hub, you can find us at Lawyers Hub Kenya on all our platforms. And so feel free to also use the hashtag Data Protection KE. If you have any comments, any public comments that you want to put on any social media platform, please use that one hashtag, Data Protection KE. Thank you very much. I think we're going to wrap it up at this particular point. I would want to invite my co-moderator for this particular session to take us to the next session that we'll be having. I want to thank you all. Please engage. If you have a question, use the Q&A tab. And we'll be able to engage. If your friend hasn't joined in, please let them know that we have very limited space on this webinar. There's a lot of registration. And so if they're unable to join, they'll be pushed over to YouTube. So ask them to join in if they have any question. We have the audience of the PS and the Data Commissioner. This is a great opportunity to give your feedback on this particular regulations. And I'm so grateful. We want to thank you very much, the PS as well as the Data Commissioner for coming to listen to our comments and our plight. We sincerely are grateful for the public participation exercise. And so at this particular point, I want to wrap it up and invite my colleague, Rose, who will take it up from there.
Good afternoon. Good afternoon, everyone. Thank you so much for joining the session today. Before I start and give an introduction of the session, I just want to welcome my boss, CS Mucheru, who is part of the participants or the attendees in today's session. Welcome very much, CS Mucheru, Cabinet Secretary, Ministry of ICT, Innovation and Youth Affairs. We also have PS Jerome Ochieng, who's a PS ICT and Innovation, and of course, the Data Commissioner, Madame Immaculate Kassait. Thank you for joining us. This is a session that is the first of the kind that we've had in this sort of setting. It is one of a series of public participation sessions that will run over the next month So this is a first that we've done in partnership with Lawyers Hub, which I think the COVID period has taught us to be innovative in how we engage in public participation. The public participation is specifically for the 3 regulations that have been drafted by the task force that was gazetted by the Cabinet Secretary, Joe Mucheru, on the 15th of January, 2021. One of its deliverables was to have general regulations. And so the task force has developed 3 regulations, one being the general regulations that has been done pursuant to Section 71 of the Act. The second one is registration regulations, which are empowered by Section 17 of the Act, of Part 3 of the Act, and the others are on compliance and enforcement, which finds the enabling provisions in Part 7 of the Act. Before I go any further, I will invite my other boss, Data Commissioner Immaculate Kassait, to give an opening remarks as well as introduce PS Jerome Ochieng. Thank you.
Good afternoon. I take this opportunity, to acknowledge our boss, CS Joe Mucheru, who is the Cabinet Secretary, Ministry of ICT, Youth and Innovation. He is a part of the audience for creating time to actually listen in terms of the contribution. I want to appreciate PS Jerome Ochieng, who is the Principal Secretary, State Department for ICT. And thirdly, I want to appreciate Linda Obonyo for this opportunity to co-host this one-of-a-kind forum, where we will be having a conversation with the lawyers and other attendees to discuss the data protection regulations. And I will be sharing with you a short PowerPoint presentation before I invite PS Jerome to make his remarks. Next slide. As a way of introduction, I want to quickly take you through the mandate. Some of you are familiar with the mandate of the Data Protection Commissioner, and the office, of course, was established in November 2020, following the Data Protection Act of 2019. And our mandate is summarized as follows. One, of course, is to regulate personal data. The second mandate is to ensure that the personal data being processed is in accordance to the Section 25 of the Act, to protect privacy of individuals, to ensure that we have the legal and institutional framework to protect personal data, and to provide data subject with their rights, remedies, and how they are protected under the Data Protection Act. Next slide. As has been mentioned, on January 15th of this year, through a Gazette notice, the CSICT gazetted a task force, and the membership of the task force, some of them are present with us here today as part of the panelists. And the terms of reference were summarized as 5. 1 was to undertake a comprehensive audit of the Data Protection Act. 2 was to identify the inconsistency in the Data Protection Act of 2019, and of course make proposals on ways of reviewing. 3 was to develop the Data Protection General Regulation, and that's why we are here today. 4 was to sensitize stakeholders and public on the Data Protection Act. And finally is to undertake the stakeholder and public consultation on Data Protection General Regulation. And this is why we are here today. So far, we have achieved the following. We have been able to identify the inconsistency and the gaps in the Data Protection Act under the Act. 2, we have now come up with 3 sets of data protection regulations, which we'll be discussing today. Consultation and with stakeholders, which is ongoing. As has been mentioned, we'll be having stakeholder consultation and public participation for the next 2 weeks. 4 is to come up with a concept paper on public sensitization preparedness, and so far we have been able to achieve 80% of the TORs. Quickly going through the draft regulations, The first regulation which will be taken through today is the regulation on the general regulation for 2020. This regulation sets out, of course, the procedure for enforcement of the rights of data subject, as well as elaborating their duties and obligations. The second set of regulation, it is on compliance and enforcement, and this sets out the enforcement provision. The third set of regulation is on the procedure that we will adopt in as far as registration of data controllers and processors is concerned. Next slide. In as far as public participation is concerned, we have said we will be having public participation on the 27th to the 29th of April, and you're invited to share your comments through the email address stipulated there, which is basically dataprotectionregulation@odpc.go.ke. What are our next steps? The next steps for us, of course, we'll consider the stakeholders' comment. We'll have consultation with the committees of National Assembly. We'll then gazette the regulation, create public awareness, and of course, most importantly, we'll also have an opportunity to develop sector-specific regulations after this one. And that's the end of the presentation. And now I take this opportunity. I take this opportunity to invite PS Jerome to give his remarks. Karibu, PS.
Thank you very much, DPC. We call her DPC, Data Protection Commissioner, for the invite. We have in attendance our Cabinet Secretary, Joe Mucheru, and to the DPC, and also Linda Obonyo from the Lawyers Hub. All distinguished participants, ladies and gentlemen, good afternoon. Let me start by thanking you all for attending today's stakeholders consultation on the proposed Data Protection Regulation 2021. I also want to start by thanking the members of the task force who have worked tirelessly to develop the Data Protection Regulation 2021 within very tight timelines, schedules, and also not forgetting the ongoing COVID-19 restrictions on movements and physical gathering, but they have gone beyond the call of duty to be able to deliver the 3 sets of regulations. As you are all aware, the Data Protection Act 2019 was enacted in November 2019 to regulate the processing of personal data, protecting the privacy of individuals, and also establish the legal and institutional mechanism to protect the processing of personal data. Subsequently, a lot of effort has been put in place to operationalize the Office of Data Protection Commissioner in order to show public confidence in the office's ability to regulate the collection and processing of personal data, including the development of the Data Protection Regulations 2021, which we'll be hearing today, as envisaged in the DPA 2019. The Cabinet Secretary in the Ministry of ICT and the Data Commissioner, being the regulation-making authorities, have drafted the Data Protection Registration of Data Controllers and Data Processors Regulation, the Data Protection Enforcement and Compliance Regulation, and also the Data Protection Regulations 2021. These statutory instruments seek to provide a framework for the implementation of the Data Protection Act 2019. As the Ministry of ICT, Innovation and Youth Affairs, we are happy to facilitate this process as a critical means of confronting the constantly evolving technology ecosystem whose main currency is data. Ladies and gentlemen, with data being at the center of the 4th Industrial Revolution, there has been a concerted effort by governments all over the world to regulate the processing activities that rely on personal data. And as a country, we too are putting in place mechanism to realize these objectives as provided for under Article 31 of the Constitution of Kenya. Data privacy laws are relevant today more than ever before because of the borderless nature of data and information, the exceptional development of technology and innovation, as well as the increased use of digital platforms across all levels of society. With increased internet penetration in our country and across the globe, increased use of digital platforms for work, education, entertainment, amongst others, it is becoming more and more important to ensure that personal data is processed and used for the intended purposes. The ministry has high expectation that this process will strengthen the data protection legal framework in the country and also build public confidence in the Office of the Data Protection Commissioner, as well as being able to promote Kenya as an attractive and competitive investment destination for global business. It is our hope and belief that this dialogue will bring clarity on the legal and regulatory frameworks that we have been developed by the task force, and also wish to encourage the public to review the same and provide relevant feedback in order to strengthen these frameworks that will go a long way in governing the data protection ecosystem in the country. Ladies and gentlemen, with these few remarks, I once again wish to thank you and also thank the task force for the job well done, as well as all the stakeholders and participants here today for your attendance. Our Cabinet Secretary, Joe Mucheru, is in attendance. I do not know whether he has something to say or he has been enabled to speak. I know there was work going around to ensure that. Very good, Waziri. Karibu sana. So let me take this opportunity to welcome Waziri to just salimia wananchi.
Yeah, mine is to say hello. I think the purpose for me was really to listen, to hear how, especially the lawyers, see this in terms of opportunity for us within the sector. We know how important these data protection laws are. We've already seen companies like Amazon now setting up in Kenya because of these laws, and many other companies. So we're expecting a lot of business to come out of this. But I'm very happy that these public participation processes have begun. Let me thank Linda Bonyo for really taking time, and together with the task force, yourself, PS, Jerome, and the DPC, Immaculate Kassait, and the task force, you've really at least taken this on, and Kenya is getting into a very important phase as we now take full advantage of data. They say that information is both power, and power is what will lead to money and many other things that we need for transformation. So mine is really to listen and observe. I've seen protocols will not allow me to just be in the audience and not say hello, but I'm happy to be participating and hearing how things are going. So asanteni sana, and God bless you in the deliberations.
Mm-hmm. Thank you very much, Waziri, for those great remarks. Then I hand over back to the DPC for the rest of the program.
I believe Linda and Rose, you take over from here. Thank you.
Thank you again to our Cabinet Secretary, Joe Mucheru, for joining. It was an unexpected but pleasant surprise. Thank you, PS Jerome, for your remarks, as well as the Data Commissioner for your remarks on where we are in the process and where we're heading through this process of public participation. We will now have a presentation by the Lawyers Hub on the 3 regulations. So I will invite my colleague for the day, Linda Bonyo, to make a presentation on the general regulations, the regulations on compliance and enforcement, and the regulations on registration. Thank you.
Thank you very much, Rose, and thank you very much, CS and PS, as well as the Data Commissioner. We are grateful for your support and thanks for this opportunity. We want to go to the regulations, so we get to layer bases in which we can ask questions and engage. Some of us had already sent in questions around the, around the regulations as well. This was already emailed, but we want to just set the basis so that if you're just joining for the first time and you haven't interacted with the documents, that we'll be able to learn something before we go to the next stage. And so we'll start from the regulations. We have 3 sets of regulations. And so with the contextual, the context will be given by Rose on exactly why, I think the task force as well, exactly why we have, what powers are bestowed on the CS to come up with the regulations, and then the other set of, procedures. So I think I'll begin from the highlights from the regulations, and feel free to take a screenshot and be able to share on social media. We have, there's a highlights around the regulations. And if you want to understand the regulations, the first part is enabling the rights of a data subject. If you've been here before, we've talked about what a data subject is. And 2, there's also provisions on restriction of commercial use of data and how you can use data commercially. Then we also have the obligations of data controllers and data processors. We also have data protection by design or default. And so there are principles that are that are outlined within the regulations. And then we have notification of a personal data breach, the process and what needs to happen. Then we also have transfer of personal data outside Kenya. We also have the data protection impact assessment and how it's conducted in terms of procedure. And then finally, we have provisions on exemptions. So there are certain exemptions to this particular regulation. So we'll go to the first one, and sorry, we'll go fast just because there's no time, but there are certain rights that accrue to a data subject. And one of the things that come out of the regulation is that there must be consent, and consent cannot be implied. It has to be expressed, even through a public notice. We also have some of the things that have been indicated that there's prohibition of direct marketing, especially direct marketing in this particular sense. We also have the use of data. It allows the use of data from surveillance cameras, facial and voice recognition technologies. We also have certain restrictions. A data subject can be able to, ask for restriction and object to the processing of their data. They can put forward a data access request, ask for rectification on their data, and also ask for erasure of data, and also data portability, where they need to move from one particular provider to the other. We also have, in terms of costs, all processes are free of charge except for data portability. And then we also have a provision at the end on the exercise of this right by others, including children, so that their guardians can be able to exercise this right on their behalf. So this is a summary of, the rights of data subjects and what applications you need to do. So application to data commissioner, data processor or controller. So the form that they need to use is form 1. If you need to object to processing, is the same. The timelines are also given. So if you want to really look at this particular, terms, please feel free to take a screenshot and be able to compare what exactly the different forms provide. Because of time, we'll go to the next slide. I hope you have taken the screenshot. So restriction on commercial use of data. So you must meet these particular conditions if you want to use data for commercial purposes. There are these conditions that personal data is not sensitive data. It must be collected directly from the data subject. So the data subject needs to consent to the commercial use of data, but you must provide a simple opt-out mechanism. So you must provide an opt-out mechanism for the data subject to be able to opt out. In terms of direct marketing, you must use personal data to identify or target the subject. So this includes adverts on media sites and even emails around sales. Opt-out message must be clearly highlighted. It must be clear, simple, legible, and the simple process to opt out so that it's not complicated to opt out of the process. And then finally, the data subject can request the data controller or the data processor to restrict use of their personal data by third parties for direct marketing. So you have 7 days as a data controller or processor to comply with this particular request. Then we go to the restriction on commercial use of data. So these particular restrictions So you must be able to look at a retention schedule. You must be able to indicate how long you're going to keep this particular data. If you're sharing data between a data controller and a data processor, then you must also have a data sharing agreement. You need to have a data protection policy, and then you also have to specify. There's a process in which you must specify what's being done in Kenya, how data is being held in Kenya. Also, the data controller and the data processor need to deal with subject requests. If somebody requests to have their data dealt with anonymously or pseudonymously, that also must be done. And you must inform a data subject about automated processing of their data. Automated processing is, the use of algorithms, for instance, to determine if you're, ready to take a loan or not, things like that. And then finally, there must be written agreements between controllers and processors. That will ensure that, we know who's liable in that sense. Then we also have elements to implement data protection by design or default. So the principles, if you look at maybe under GDPR, there are certain principles on accuracy, so that the data that you're collecting is accurate. Data minimization, don't collect more than you need. For instance, if you run a building and there's a guard who's taking data, they don't need somebody's grandmother's name, they just need maybe your name and ID to access that building. Then confidentiality and integrity, that's a principle that's outlined in the regulation. Purpose limitation, you only collect data for the purpose, you use that data for the purpose in which you collected and let the data subject know. There must be transparency and lawfulness in that case. So let's go to the next slide. Notification of a data breach. If there is a data breach, you need to notify the data commissioner. And so there are classes of data whose breach is notifiable. So you can see proceeds from insurance, policies, investments in capital markets, net worth or creditworthiness of a data subject, employee wages, account and credit card details, deposits, loan facilities, as well as information on children in conflict with the law. So these are classes in which that data breach must be notified. So if you want to transfer data out of Kenya, there are particular conditions for cross-border transfer. There must be evidence that there's appropriate data safeguards. For instance, the regulations mention that country must have ratified the Malabo Convention. There must be maybe a reciprocal data agreement with Kenya. And also the data commissioner will be able to designate certain countries in which you can have cross-border transfer of data. Also, there must be consent from data subjects. It's an offense to obtain consent by providing false or misleading information. And then finally, there must be a written agreement between transferring and the recipient entity in that particular country. We also have the data protection impact assessment. So the regulation provides for impact assessment. It defines the categories of data that amount to high risk of processing. It provides a template to conduct data protection impact assessment. It allows for consultation with the Commission when carrying out a data protection impact assessment, and then a publication of the DPIA by the controller. And we also have periodic audits that will be conducted by the data commissioner on how you are, complying with the impact assessment. Then provisions of exemption under the Act, and this is the last one. The Act, the regulations exempt certain categories. So it clarifies exemption for national security or public interest. So national security is processing by national security organs, e.g. NIS, KDF, or national police in the exercise of their mandate. Then we have controller or processor who has obtained a certification of exemption from the cabinet secretary. So if you need an exemption, you must apply to the CS. Then there's also on public interest. So public interest, there's two aspects that's given: public health or a general permitted situation. So depending on situations in which you can get this exemption. So that is it, I believe, from the general regulations. And sorry if we went too fast, we'll be able to share this particular provisions on general regulations. So we go to the next set of regulation, which is on regulations on complaint, I think, how you're able to do a public complaint.
Compliance.
Yeah, compliance and enforcement. Okay, so I just saw it as a user. I'm like, oh my God, this is how we complain. So let's go to the next regulation. So the next regulation is on, as you said, there's 3 regulations that we're discussing. The next regulation is on compliance and enforcement. And so on compliance and enforcement, we have the highlights on how to lodge a complaint, the process in which the complaint takes on registration and screening, then discontinuation and withdrawal or joint consideration of complaints and the language in which it happens. And then we have notification of complaints to respondent and investigation. And then finally on enforcement. So this particular regulation gives effects to section 31, 54, 61 of the Data Protection Act on, and basically I think most of it is on the data subject, on how you can go through this. So let's go to the next slide on who can lodge a complaint. You can do that in person or somebody acting on your behalf as authorized by the law. And so I know lawyers are asking if this is, that opportunity in which they represent clients. And how do you do this? You use Form 1, or you can orally do it subject to section 56, subsection 3. And it's recommended that you do it online. I think we'll be able to also clarify this from the task force through any electronic means. So we go to the next slide. Registration and screening. So the office will acknowledge, the Office of the Data Protection Commissioner will acknowledge the receipt of the complaint. The commissioner will maintain a register of complaints, and screening will be done to admit any complaint or advice on the complaint or decline that particular complaint. Where there's no issue raised under the Act or it's trivial, vexatious, or not in good faith, then the commissioner will be able to decline that particular complaint. Next slide, please. Discontinuation and withdrawal. So upon screening, the DPC may conduct an inquiry and conduct this particular investigation. If it's not valid, then they'll be able to discontinue that particular complaint. A complainant may withdraw complaint at any stage before determination. So if you're wondering who is this complainant, maybe it's you who keeps receiving SMSs that you do not want to, or you shared data that now is out there, maybe there's a data breach. We go to the next slide. So there may be joint consideration of complaints, and in this case, if there are 2 or more complainants against a respondent, then they may be consolidated into one particular complaint. The language that can be used is English, Kiswahili, or Kenya Sign Language. Then the investigation of the complaint will be done via summons. There will be examination of persons, administration of an oath during the proceedings, and this will be evidence-based. There is opportunity to steal the powers to search and seize as well. There will be an issuance of investigation reports, and if you're looking for the remedies that you could get, there will be maybe an enforcement notice to the respondent. There can be a penalty notice for fine. There can be a dismissal. There can also be recommendation for prosecution, and there can be an order for compensation. So those are the remedies that you can be able to have. So as you can see on the enforcement, there can be issuance of an enforcement notice. Then we go to service of that enforcement notice. There can be a review. Any appeal lies in the High Court. There can also be an issuance of penalty notice and enforcement of this particular penalty notice. That is it on the enforcement. So we go to the next, the last presentation, which is on, I think maybe this is relevant for those who are running businesses and are wondering, how do you register as a controller and a data processor? Allow me just to say this again. If you are, you're wondering who is a data controller and a data processor, I think that's in the first slide, just to clarify who is the controller and the processor. Let's go to the next slide. So the highlights of this particular regulation is one, it lets you know how do we determine the data processor and the data controller, how do you apply for registration, how do you verify, and then have a certificate of registration, then on renewal, which is annual, and refusal of registration. Then we also have exemption from mandatory registration, who is exempted. And then finally, we have fees, electronic application, and offenses. So if you're wondering who is the data controller, this particular regulation gives effect to section 18.2 of the Data Protection Act to provide for the procedure for registration of data controllers and data processors. It does not apply to civil registration entities under the Data Protection Civil Registration Regulations. I think this was discussed during COVID. That is already in place. So next slide, we have, how do you determine data controller? A data controller is that person who determines the purpose and means of processing data. They may apply for registration as a controller and a processor, so you can be both. A data processor processes personal data on behalf of the data controller. So imagine that you work maybe for KQ, let's say as a social media influencer, for instance. So you are a third party. If you are a ticketing agent, you are that data processor working on behalf of, let's say, the Kenya Airways, for instance. So data processor processes personal data on behalf of data controller, but it excludes employees of the controller. and has a contractual relationship with the controller and has no decision-making power as to processing and purpose of personal data. So how do you apply for registration? You need to provide a copy of the establishment documents, how you're registered, maybe as a company, limited by guarantee, an NGO, whatever it is. Then you need particulars of controllers or processors. You need to provide that. You need to describe the purpose for processing of data. You need to also describe the categories of personal data that is processed, any relevant information. And just as a note, public bodies at national or county government which operate within a state or county department and are wholly funded by the Exchequer and provides public service must register. So if you get money from the Exchequer, you must register. There's an exemption to that particular provision and says that state corporations or county corporation are exempted from this particular regulation. So verification and certificate of registration. So once this is received by the Office of the Commissioner, they would conduct a verification process. If satisfied, then they'll be able to provide a certificate of registration and enter you in their particulars within 14 days. So the certificate issued is valid for 1 year, and the certificate must be displayed at a conspicuous place and at the principal place of business or on the official website. And the certified copy must also be put at each branch if you have different branches. So renewal and refusal of registration, renewal must be done 30 days before expiry of the certificate of registration. So this is year 2 that we're talking about. And it must be determined within 30 days from receipt. Where the application of renewal is declined, the data commissioner shall within 21 days notify the applicant with reasons. They can also decline where particulars provided for inclusion in the entry are insufficient, where you haven't shown appropriate safeguards for protection of privacy of data subject, or where you violated the act. So a fresh application may be made upon compliance with this particular requirements. So what are the fees, applications and offenses? The fees can be charged for approval of data impact assessment, the provision of a compliance support. So if you need compliance support from the Office of the Data Commissioner, conducting compliance audit, facilitating third-party due diligence like you do at companies registry, inspection or such on the register. So those will have separate fees. You can also apply for a certified copy of the certificate if there's any loss or if the certificate is destroyed, you can apply for a replacement of the certificate as well. So applications in the regulations, you have to apply through electronic means in this particular case. We also have finally on the offenses. So processing personal data outside registered scope is an offense. Processing personal data for other purpose than registered is an offense. Unauthorized disclosure to third parties is an offense. Transfer of data to undisclosed territory is also an offense. So these are the costs as per the schedule. As you can see, an organization for, with 1 to 9 employees, the renewal fee is 1,000 bob, and the maximum, an organization with more than 99 employees, the renewal is 12,000 bob. The first cost is 15,000. Then also there's a stage 2 on annual turnover. This excludes public authorities and charities. The cheapest is if your annual turnover is less than 2 million, you pay 2,000 shillings on application. Renewal is 1,000 and 25,000. If you are an organization with more than 50 million in annual turnover, you pay 20,000 shillings. Special category of data where you process data and it's data intensive. You have personal data that you're processing. It's 20,000 Kenya shillings. So these other costs, approval of data impact assessment is 15,000. Compliance support fee, audit fee, third-party due diligence will be determined by scope. Updating or change of particulars is 1,000 shillings. Certified copy of an entry of data register or certificate is 500 shillings. And the certification fee is 250,000 shillings. I believe that's the end. I want to thank you all for sitting it through. Those are a lot in terms of regulations, but I'm really grateful to the team here, Rispa and Kate, who put this together at the Lawyers Hub. Thank you very much for the good work, as well as the team that's with me here, Ken, Luisa, and Selina. Thank you. I'd also want to just acknowledge Robert Karanja, who's joining us. He's a director at Omedia Network. And we are supported by Omedia Network for some of our programs, including data protection programs. So we really thank Omedia Network for the support. So at this particular stage, I want to welcome my colleague, Rose, from the Office of the Data Commissioner, who's going to take us through the next question. If you have a question, as we had indicated, please go to the Q&A tab. I see a lot of questions, I think over 50 questions already. And so the task force is going to be able to answer your questions at this particular point. If you're on Twitter, please use the hashtag Data Protection KE. And you can find us on Twitter as well. Please follow us, ODPC_KE. That's the Twitter handle for the commissioner, and Lawyers Hub is Lawyers Hub Kenya. I think that's it from me. I will now proceed to the Q&A section.
Thank you for that, Linda. I didn't know that the regulations could be read out so quickly, but thank you for the presentation that has just been done. As we get into this session, I just want to remind participants that this session really is to enable you to give feedback on the regulations, but also to understand the nature of the regulations. They're new documents that were only published last week for public participation, and so some of you might not have interacted in depth with them. And this session again is to provide clarity to what the task force thought was necessary, what it thought, how it wished to best serve its TORs or terms of reference. And so as we go through this, I urge everyone who's participating today on behalf of the rest of the task force members, those that have joined and those that weren't able to join, that you critically look at the 3 regulations that were published and provide feedback. I think there is if you go to the odpc.go.ke website, you should be able to get a copy of all 3 regulations, and we are open for to receive the comments that you have. So if you send your comments to data protection regulations at odpc.go.ke, we will receive your comments and we'll be able to take them into account as we go through the process of public participation. So I will take this moment to acknowledge the task force members that are with us presently. Myself being one of them. We have the chair, of course, of the task force, Madam Immaculate Kassait, who's also data commissioner. We have with us Thuranira Gatuyu. We have Dr. Humphrey Njogu. We have Marian Murithi. We have Miriam Kakenya, and we have Victor Nzomo. So how we'll undertake this session is I will look at the questions that you have. I'll take 5 at a time, and I will distribute them to the task force members that are present. So if we can go to the questions. Okay, GDPR gave this is anonymous attendee, I guess all of them are. GDPR gave a compliance timeframe of about 2 years. Will there be a timeline for institutions to comply? Requiring a copy of, the second question, requiring a copy of data to be kept in Kenya. What does this mean in this era where most businesses have invested heavily on cloud computing, where servers could be anywhere in the world? The third question, can ODPC consider issuing lifetime licenses just like what CBK does, with an option to withdraw for offenses, but renewal fee can be paid annually? And I think the last question that we take is, one of the functions of the DPA, Data Protection Act, is to register data processors and data controllers. This has quite a number of questions under it. So it says, what are the requirements to be registered in either category? Are there any fees involved? Does the registration requirement apply extraterritorially to processors or controllers in other countries? Can a firm be registered so that its employees may process or control data? I'll stop there because there is the question is divided into 2. So we'll start firstly, and I will invite, I think I can, if Madam Kassait wants to answer the first question. I don't think she was prepared for this, but I'll ask her to anyway, because it's an administrative issue. The first question was in regards to giving a time frame for compliance with the regulations similar to what the GDPR did. And if Madam Kassait isn't able to, I will answer that question for her.
Ruth, go ahead, you can answer.
Okay, thank you. the task force looked at this issue and determined that this would be a matter that would be dealt with administratively. So once we have the regulations go through public participation, we're still quite some way away. We then have to take it to Parliament to go through the legislated committee that, the committee that deals with regulations. So once that goes through and the regulations are passed, we will be issuing, and when I say we, the Office of Data Protection Commissioner, the Data Commissioner obviously being the person to issue guidelines, will be the one having to state the timelines for compliance in terms of registration, in terms of DPIAs and everything else that needs guidance pursuant to the regulations that have been formulated. So that is that. I will get Thuranira to answer the second question, which is in regards to, actually, I'll get Thuranira to answer the second and the third question, which is regards to, I think, localization of data in terms of cloud computing and what that means. Also in terms of issuing lifetime licenses and what that would look like. So Thuranira, the floor is yours.
Thank you very much, Rose. I will deal with the question of data localization. Now, a start point is the section 50 of the Act, the one which gives us authority to deal on this issue. And it provides that the Cabinet Secretary may, either for purposes of strategic interest of the country, make declaration on certain processing which must be carried out through a data center or server in Kenya. Now, this one is not a blanket, it only applies where there is a strategic interest. Now, the task force looked at this issue and what are those strategic interests of the country or protection of revenue. And that's why we came up with only 8 situations on where the processing must be carried in Kenya. And if you look at these ones, mostly they are the ones which are involved in providing a public good, and they generally entail the government. We have like civil registration, which is for government, operating a population register, managing or facilitating access to education, conduct of elections, things like that. Now, if you don't fall under that category, which is listed there in section regulation 25.2, then that requirement does not apply to you, but you process it everywhere. Of course, this one now will target the government, and the anticipated positive externalities, which will be occasioned by having this data center in Kenya, is provision of infrastructure, which even the private sector will piggyback and even reduce the cost which is there for hosting the data in Kenya. So that is how it is, but for this juncture, it's mostly of public entities or which are of high strategic interest. Now, the second concept, I think it's more of a summation, is that we consider issuing a lifetime license other than the periodic license, like that's all the commenter said. Now, that is the aspect which we'll consider, even though as we consider the cons and the pros of all of them. And a lifetime sentence is usually something like a spectrum, where you are being licensed to continue. But this one, where you have to ensure compliance, the compliance, it is usually a good, we have one which is routine, but that's a good feedback which we will consider. Thank you very much, Rose.
Thank you so much for that, Thuranira. The next question, which was in regards to the registration of data processors and data controllers, what are the requirements to be registered in either category? Are there any fees involved? Does the registration requirement apply extraterritorially? Can a firm be registered so that its employees may process or control data? I will pass on that question to Victor Nzomo if he's in the chat.
Thank you, Rose.
Proceed, Victor, we can hear you.
As well, thank you.
Sorry, Victor, I'm not sure what happened, but we couldn't hear your response to the questions.
Sorry about that. I hope you can hear me now.
We can.
Great. As covered in Linda's presentation, the aspect of registration of data controllers and processors is part of the regulations that we developed. So I think all those aspects are covered in that particular set of regulations. Thank you.
Thank you so much for that. The question that was following that from the same person says the Act makes public various privacy protections for the public and shows natural persons how to pursue a remedy and how enterprises can comply with requirements. Are any implementation regulations under draft or review? Have there been any cases in court on this issue? I'll take other questions as well. Another question is, in regulation 51A of the general regulations state that a data commissioner may compound an offense under section 58.8 and 74 of the Act. However, section 58.8 does not exist, and section 74 speaks about commissioners providing guidelines, codes, etc. in this. Is this an error in the Act? Thank you. Another one, Jay Kihanya says, congratulations on the regulation development. So I don't, the questions that Mr. or Mrs. Kihanya, or I don't know which gender, says mutual respect between the ODPC and regulated public will be key. What mechanisms will be forefront in the ODPC's work? What regulatory policies will be pursued? So I'll pass that through. The first question is in regards to, sorry, if we could just scroll up. Again. Thank you. It's in regards to implementing the regulations, and are there any implementing regulations? I think I can take that without passing on to the task force. In terms of the regulations, these are the regulations that will give implementation clarity, as well as enable operationalization of the Act. And so these are those that you're asking about. Have there been any cases in court on this issue? Strictly not on data protection aspects, as it's generally a very new area in the law. There have been cases that touch on data protection, but not brought under the Data Protection Act, where the data commissioner has been explicitly named, save for obviously the Huduma number case, which I think we're all familiar with. In terms of the general regulations, this is a question as to the compounding of offenses. If Thuranira, you could answer that question.
Thank you, Rose. The issue of offenses, I'm sure that's what the member has asked on the compounding of offenses. Now, what happened is the Act creates the offense, that's the statutory mandate. Now, on how that offense is prosecuted, it's usually the domain of the DPP, Director of Public Prosecution. Of course, in this case, the office will be the complainant. Now, the Office of the Director of Public Prosecution has generated what is known as diversion policy guidelines. Now, diversion policy guidelines tries to give effect to Article 159 on how a matter can be settled without necessarily having to follow through the chain of prosecution. And one of the tools which the ODPP, the Director of Public Prosecution, has recommended is the compounding of offenses. And of course, the guidelines on the DPP on how we compound. So what these regulations have done is to import the diversion policy into a regulation, because there's already a policy which is there, that if in case you have admitted an offense, then of course, and there's a concurrence of the DPP, instead of you being prosecuted and you have yet admitted, then that penalty, mostly it's usually 3/4 of it can be levied. It's a good strategy which is contained in the diversion policy. So there's actually no contradiction, but the regulation are giving life to section 74 of the Act. Thank you very much, Rose.
Thank you so much for that, Thuranira. In terms of the mutual respect between ODPC and regulated public, this was a question by Jay Kihanya. I will take this one because it's an internal ODPC issue. The Act provides for creation of awareness of the provisions of the Act, and obviously the data subjects' rights and obligations of data controllers and data processors. The office is fairly new, but we have undertaken to engage as many partners as we can, including eventually going out to different counties to engage in creation of awareness of what the rights of the general public will be. And so this is still a work in progress. One of the things that we need is regulations first, so that even as we go out to create awareness, there is specific provisions that are implementable pursuant to the Act and the regulations that we can advise data subjects on, as well as data controls and data processors who are not located in urban areas. The next question that I will take, and I will take 4 now, will be from Maureen Mwende. How does the DPA impact private entities, let's say a manufacturing company? 2 is, if ODPC will, has the jurisdiction of a tribunal in the hierarchy of the judiciary in Kenya, what checks and balances exist in its function as investigator, prosecution, and arbiter? The 3rd question is, does the mandate of the ODPC extend to complaints on alleged breaches occurring before the Act came into force? And 4, shall the ODPC pursue light touch or technical arbitration processes? So in terms of the DPA impact private entities, can I give that to Marian Murabi?
Yes, thank you, Rose. Yeah, in terms of the application of DPA to private entities, yes, DPA applies to private entities, and that is also contained in the Section 4 of the Act, which provides that this law shall apply to public and private entities, whether they're using automated or non-automated means, and also whether they're established in Kenya and processes personal data for Kenyans. And also, if you're not established in Kenya, you process personal data for data subjects who are located in Kenya. So private entities are covered within that scope. And for instance, if it's the manufacturing sector, whatever data that you process that relates to data subjects, and data subjects, the Act clearly defines data subject to mean a person, identifiable natural person who is the subject of that personal data. And that could include employee data and any other data that manufacturing company could be able to, is actually processing. The other question is on checks and balances that the office has, undertaking investigation and also sort of handling complaints procedures. So here I would say that the Office of the Data Protection Commissioner is designated as a state office, and therefore it is independent to carry out its function on data protection here in Kenya. It shall undertake a regulatory role and also has an internal inbuilt, complaint handling procedure. So in terms of oversight, the ministry has its role. The Ministry of ICT has its role. Therefore, they shall undertake this function in collaboration and consultation with the ministry. And also the Act provides that the Office of the Data Commissioner shall report its activities to Parliament. So therefore, that oversight shall be dealt with at that level. Maybe also I can mention this bit on processing activities which are undertaken prior to enactment of this Act. You see, when you enact a law, it's supposed to act prospectively, not retrospectively. So if there were any breaches that were done prior to the enactment of this law, and this law provides for it as an offense or as an offense, then it will be determined at that point by the courts. But basically, this law is prospective and it's supposed to cater for breaches within the context of what is provided in the Act that started from the time the Act was enacted in 2019. Back to you, Rose.
Thank you so much. There was a 4th question in regards to, shall the ODPC pursue light touch or technical arbitration processes. I think that is a matter of course, for the data commissioner, the understanding that we're going in, and data commissioner, if I'm wrong with this, please correct me. But we hope to ensure that we're having initially a light touch in terms of ensuring that there is conciliation taking place. And I think the Act provides for mediation, conciliation, and arbitration if need be. The Office of the Data Protection Commissioner would wish to have engagement between the parties before taking it to the next step should a dispute arise. The next question, the next questions, I'll take another 4. To what extent is the Huduma number digital ID project's data protection compliant? Then there is, does the ODPC intend on developing additional guidelines to supplement the cross-border transfer under Part 4 of the DPA and Part 5 the Data Protection General Regulation? This question is raised in consideration of the fact that there are no guidelines on evaluation matrix that the ODPC shall consult when determining the adequacy of a foreign country's data protection framework as anticipated under Section 41C of General Regulations. Furthermore, the provisions that permit derogation from cross-border data transfers enshrined under Section 39B to 39D are extremely vague and can be used by shrewd transferring entities to circumvent the cross-border data transfer obligations. So we'll deal with that. The next question is, what will the purview of the Fair Administrative Action Act to the work of the ODPC, and what beyond the guidelines and manuals will guide the ODPC's regulatory actions? And the last question is there room for legal aid for complaints under ODPC regulatory purview? The first question, Huduma number, I will start with that. Unfortunately, to Claire, who I think is the one that asked the question, this is a matter presently before the courts, so I will not comment, nor will I ask any of the task force members to comment on this. An additional thing is that there is also a confidentiality matter, which is part of, I think, Section 9 of the Act. So we're not obliged to disclose such information at this time. In terms of the guidelines for cross-border data, I haven't heard Dr. Njogu's voice. So Dr. Njogu, if you would please take that question. And then the issues of Fair Administrative Action Act, as well as legal aid, I'll give that back to Thuranira. Dr. Njogu, the floor is yours in regards to the cross-border data transfers.
Yes, thank you very much, Rose, and thanks a lot for these questions that we are all raising. Yes, regarding these additional guidelines to supplement the cross-border data transfers, yes, the Office of the Data Protection Commissioner will from time to, that the office actually will keep on developing additional guidelines that will actually try to clarify issues that are not very clear in terms of what you have in the Act and also what you have in the regulations. Yes, there are plans, especially to clarify on some of these issues that are not very clear. But I think with the presentation that was done by Linda, CS has the authority to, also with the consultation with the Office of Data Commissioner, he has the permission to, or he has the provision to develop to guide on the development of these aspects of how data is going to be moved from one country to the other. Yes, it's very true that we might also need to think about that, but I think that one will come later with the additional challenges that we see with the regulations once they are put in place. Then I also want to say that in addition to these guidance that I've just said, the Office of the Data Commissioner is planning also to develop various guidelines to guide many aspects that are there. So for instance, like the data protection impact assessment. So there are plans to develop that. There are also plans to develop guidelines to guide on legislation, and specifically for the sector specific regulations. I mean, sector specific guidelines on that. So yes, I think yes, it is it's going to be done once we have these regulations get approved. I think that's what I was to respond, Rose. On
yes, thank you so much for that. Thank you for that, Dr. Njogu. Theronera, if you could comment on the issue of the Fair Administrative Action Act and how it will govern the work of the ODPC, as well as whether there's room for legal aid for complaints under the ODPC regulatory purview.
Thank you so much, Rose. Now, on the Fair Administration Act, the second set of regulations, which is the compliance and enforcement, has made that very clear that all the operations in relation to a complaint or furthering a complaint or taking an enforcement action by the office must be governed strictly by the Fair Administrative Act. And it has to be done so because you see this act is meant to give effect to Article 47 of the Act, which embodies the issue of the fair administrative action. Therefore, the second set of regulations has made it very clear that this act will be embodied in all the administrative action as will be taken by the ODPC in furthering of the mandate. So we confirm it's there, and it's in fact measured in a succinct way in the second set of regulations. Now, on the issue of legal aid, on whether the office may provide a legal aid. Now, if you are prosecuting a complaint on the office, in Kenya we have a Legal Aid Act of 2016, and the Legal Aid Act, it sets up the National Legal Aid Service, and also the other entities, the legal service provider, which can be accredited through that act. So if you have an issue relating to a complaint which has been lodged there, or you can seek any assistance through the mechanism provided in that agency, and then you can come. But the office itself, their work is to protect, to ensure there is a protection of personal data, and not necessarily to provide a legal aid. However, as it is very clear in the regulation, making a complaint in the office of any complaint about your personal data is free of charge. So there will be no free of charge. But of course, if you want assistance, government as that the agencies which can always offer the legal assistance as any citizen may wish. Thank you, Rose.
Thank you so much for that. We'll proceed with taking the questions. There are quite a number. So again, we'll take 4 at a time. What does a policy and regulation provide in the context of child protection? This is based on the fact that there is data mining that could pose risks to children online. That's from Pauline Anubi. Jay Kihanya has 3 questions. Will notifiable breaches presuppose compensation to the complaint? Is there a procedure for consents on breaches to be filed and enforced as orders of the ODPC and the courts? And what is a review path for aggrieved parties to ODPC decision, i.e. can there be a borrowing from other regulatory offices in Kenya? So Pauline's issue in regards to child protection, I will give that to Miriam. And I think let's do, Miriam will take the first question from Jay Kihanya as well, which is in regards to notifiable breaches presuppose compensation to the complainants. And then the 2 in regards to consent and the review pathways, I will give to, bear with me, I'll give to Mariam. I don't know whether Miriam's on the call, Miriam Kakenya.
I can handle for Miriam.
Thank you, Mary.
Thank you. The one for child protection, the Act is very clear under Section 33, and it provides that the consent of the parents or guardians shall be sought, and also the best interest of the child shall be of paramount importance when processing personal data related to children. Therefore, there's a higher level of protection of data related to children, and also the Act has expounded on that. The other question was notifiable breaches and compensation. Yes, when there's a breach that has occurred and the compensation is determined by the Office of the Data Commissioner, that shall also be determined. The Office of the Data Commissioner also has power to order compensation where there are breaches, and those breaches have been occasioned by negligence on the part of the data controller or data processor. Then with respect to the procedure for consents on breaches to be filed and enforced as orders of ODPC and the courts, of course, you see that we've also invoked the aspect of ADR, where there are complaints, the parties can enter into an agreement, and those agreements can be enforceable in a court of law and also can be adopted as decisions that are also enforceable before a court of law. Then finally, what is the review path for aggrieved parties to the ODPC decision? Can there be a borrowing from other regulatory offices in Kenya? Yes, of course, we have provided in the regulation that the regulation on compliance and enforcement, if you have lodged a complaint and the Office of the Data Commissioner has made a determination where you are aggrieved, you have a leeway to go to court and appeal or seek a remedy there. And also you can seek a review of that decision within the framework of the office. And therefore there are different avenues within which you can have your concerns addressed. Thank you, Rose.
Thank you so much for that, Marion. The next questions are, what are the specifications around non-commercial data use by governments? Would it be advisable to have a hierarchy of the ODPC's output in guidelines and manuals? Is all that should be in the regulations? Sorry, that doesn't make sense, but I'll read it anyway as is. Is all that should be in regulations be in it and not manuals in case of conflict? And that's again, Jay Kihanya. We've got a question from Isaac Rutenberg. For commercial use of data, you have indicated that consent is to be of the opt-out variety. Why was the decision made not to make this opt-in consent? Is this consistent with Section 37 requiring an entity to seek and obtain express consent? And the fourth question is, can you please confirm if personal data, including health data, be transferred outside the country borders with appropriate safeguards, including data agreements and consent? So if we can have, rather than having multiple people deal with that, if we can just have Thuranira answer those questions.
Thank you, Rose. Let me answer the question by Daktari on the issue of consent. Now, how we have put it, you get the opt-in. Okay, there's no word we have used like opt-in, but generally the consent during collection is opt-in. So that is opt-in, and because it's in the Act, does not require a lot of elaboration in the regulation. Now, what is the issue is, and the mischief you are trying to cure is, after now, maybe you have given your consent for the collection of personal data. How does it apply? As a benchmark, using using personal data for commercial purposes is not expressly prohibited, but it's restricted. It's restricted by this way. First of all, don't use the sensitive personal data for commercial purposes. That one is now the one which is prohibited completely. But if you have used it, then you must ensure there is consent. That is an underbelly. So that one is provided for in the regulation. But now the quickest mechanism which we are regulating is the opt-out. And in that opt-out, we are stating on how
the message for opt-out should be. It should be clear, simple, and prominent, and every message should have a opt-out. And in case somebody has opted out or has made an opt-out, then that ceases the measure of using direct marketing for commercial purposes. And we have also elaborated what does using data for commercial purposes mean. So I think we have elaborated, but if there's something which is not clear, which Dr. Rottenberg is raising, you can always give us some elaboration, and we can always clarify in the regulation. Thank you, Roger.
Thank you for that. There were a number of questions, Thuranira, that in regards to what are the specifications around non-commercial data usage by governments. There was also one in regards to the hierarchy of ODPC output and guidelines and manuals. Is all that should be in the regulations, which I can answer, be in it and not manual. So let me take this one. And then you'll deal with the non-commercial data use. In terms of the hierarchy of ODPC's output in terms of guidelines and manuals, obviously the Act has primacy, and then the and then the regulations. The guidelines are to give clarity to the Act and the regulations. There are some things that are moving constantly and evolving constantly, especially in the space of data protection. And therefore, not all can be captured under the regulations, and not all can be captured under the Act extensively. And so things like, say, for example, I think we've got two guidelines that are out already. This is a DPIA, Data Protection Impact Assessment, and the consent guidelines, which effectively just give practical guidelines, practical guidance to how the regulations will be reviewed and how they will be read, so that data controllers and data processors can comply. We understand the regulations, not everyone is a lawyer, and so they do need to have very clear steps on how to actually comply, and so the guidelines will give this. And the guidelines will obviously be guided by the regulations. In terms of health data transferred outside of the country and country boundaries with appropriate safeguards, I'll also give that to Thuranira. So Thuranira, if you could answer those questions in regards to specifications around non-commercial data, as well as health data being transferred outside the country's borders with appropriate safeguards.
Thank you, Rose. Sorry, the first question had a lot of me, but now I've got it. On the non-commercial use of data, or if you are using data for other purposes than commercial use of data, then the concept of commercial use of data will not apply. Therefore, that is not within the purview of the section, that one which has commercial use. That one now will have got in the territory of the further use of data, because if you are using it for non-commercial, let's say I give you my personal data for purposes X, and you have used it for purposes Y, and that purpose Y is not for commercial. Because what amounts to commercial use of data is where you are using a data to gain a commercial competitive advantage. And we have given description of that, like when you are sending a catalog or a direct marketing message or something like that. That is what amounts to a commercial use of data. Now, non-commercial use of data is what I would classify as further use. Now, further use is another concept which we have standalone provision for that. And we are saying that we have even provided clarity on that you should not use data for other purpose than the purposes which you collected that data. Number two, if you use the personal data for any other purpose than the one which you collected, you must go and seek fresh consent, unless the exemptions apply, like for the ones which are provided for, like for health purposes and things like that. Therefore, the non-commercial use of data or further use of data, it has been as an middle ground or as a basis been prohibited unless there is consent. So maybe that elaboration of the two concepts, maybe I've made it. Now the second concept which has been is the transfer of data out of the country, especially on health data. Now, one of the basis for doing a transfer of personal data out of the country is you have to get consent of a data subject prior to transferring it. Now, consent is also not enough. You also have to certify that the country in which you are transferring that personal data as appropriate security safeguards comparable to the one in Kenya, or the one which are deemed by default, if the Kenya has like a reciprocal contract with them. But of course, there has to be a consent before you transfer personal data out of Kenya. When there is consent, you have to transfer. But if there is no consent, then you must clearly go and certify the requirement that that country you are transferring, we are calling it the recipient, because we have the reactors, the transferring, the recipient, and data in transit. You have to certify that the recipient has adequate data security safeguards, has been accredited by the office as having adequate security safeguards, or as ratified the Malabo Convention, because that one is a deeming, what we deem is to have the adequacy. If you have not made that one, then such a transfer, of course, will be an illegal transfer, and it will attract the enforcement actions by the data commissioner. Thank you, Ross.
Thank you so much for that, Thuranira. There are a few more questions. So Jay Kihanya asks, given the forms and regulations may not be deemed as part of regulations and that it may take time to amend regulations, what forms and contents of forms allow for ODPC's discretion to vary and amend requirements? Should there be optional and mandatory requirements in the form? The next question by Valentine Achungo. We have been facing challenges when it comes to compliance with the DPA, especially when it comes to usage of software and machines that automatically store healthcare data and information in servers situated outside Kenya. Without a fully operationalized DPA, how can we ensure compliance and not be found liable for non-compliance? The third question by Jamie Willis, will the UK and EU with the GDPR be deemed as having adequate status for cross-border transfers? And the last question is Jamie Wallace again. What is classified as data transfer, including cross-border transfers? Is it just the storage of data collected, or does it include further data processing activities, including accessing or viewing the data? So if I could get Dr. Ndogu to answer the issue in regards to the forms, issue in regards to DPA compliance with healthcare data, and the last one in regards to data transfers, including data border transfers.
Thank you very much, Rose. Regarding the forms that are attached to these draft regulations, what we did as a task force is to look at the critical data that will actually be required to implement the Act. So we took some time to look at all these requirements. So yes, we have now put all these requirements, and I think we are now looking at or seeking for your input in telling us what we have missed in this. Yes, I think for now we just want to have this as part of regulations. There is a question that says, should there be optional and mandatory requirements in the forms? We want to make these, as the way forms are, we have put all what is required to support the operations of the Office of a Data Commissioner. So, but in case maybe there's anything that you feel that we have not put, we really appreciate to have that incorporated into this. So the danger of when you put something to be optional, I think you may not be able to. Most of the time, respondents may not, they may not provide that. Yes, Rose. I don't know whether it's.
Yes, thank you so much, Dr. Njogu. If you could also answer the issue in regards to data transfer, including cross-border data transfers, and will this be dealt with as is storage considered, or is any processing activities, including accessing and viewing of the data?
Thank you so much, Rose, for this. Yes. Now, for the data that is going to be, yes, there is this question that is saying that
Sorry, Dr. Njogu, I'm not sure what's happening, but we can't hear you. Oh dear. Could I ask Thuranira to take over from where Dr. Njogu was?
Thank you, Rose. I can take over from where Dr. Njogu has left on the cross-border transfer of data. And of course, let me repeat again from the concepts which we have. Out there, the architecture, the way we have designed the architecture to give effect on the act is having 3 actors. Each of them who has the responsibility. Let me say 4 actors. We have the transferring entity. This is the entity in Kenya which wants to transfer data to a territory which is out of the country. Then the second is the commodity, the data in transit, and the institution which is assisting that, maybe the one which provides the optic fiber or something like that. And then we have the recipient organization. So those are the 3 actors. Now, if you are transferring a person data to an institution, to a territory, let me use the territory because it's not a massive a country, which has adequate security safeguards, and the data subject has approved such a transfer during collection or something like that, then that is very okay. Now, the second issue is if you want to transfer that data out of the country, and you are not very sure whether that territory has adequate security safeguards, then you confirm with the authority whether that territory has been accredited. So somebody asked about GDPR. Of course, the commissioner may decide when they are doing accreditation that all the institutions that are certified GDPR, they are adequate. But you see, that is administrative because the GDPR has not, the international relations, they have not recognized us, so we recognize them during administrative. Now, if you are transferring to that territory, then it's not prohibited, and of course you can always do the transfer. So there's no banning of the transfer of data out of the country, but you have to abide by the provisions which are there, and the aim is to ensure that that personal data is protected wherever it will be. So I think that's the architecture of the transfer of data out of the country. Thank you, Rose.
Thank you so much for that, Thuranira. There was a question by Valentine in regards to compliance with DPA, especially when it comes to usage of software and machines that automatically store healthcare data, information and service outside of Kenya. What I would do, and I guess this is an operational issue, if you have, I guess a lot of you are lawyers, if you have clients whose whose processes automatically save information outside of the country, the Act still provides that the data commissioner can give the adequacy provisions can be dealt with by the data commissioner at present. So if they're in a country that has adequate data protection laws, I'd advise that you write to the data commissioner to seek guidance on whether that country is safe to have that data transferred to. Otherwise, you run the chance of being found liable for non-compliance, even presently, because the DPA does apply, if that information is, if there is a notifiable breach of any kind, given that it is sensitive information. In terms of will the UK and EU, with the GDPR be deemed as having adequate status for cross-border transfers? This is a matter to the data commissioner, given that the Kenyan data protection laws were modeled ever so slightly on the GDPR. It is likely the data commissioner will make a determination for the UK and the EU countries to have the adequate status. I think Thuranira has touched on that. However, this will be dealt with on a case-to-case basis. I'm sure the data commissioner can deal with that when she's addressing her closing statements. I will now pass on the Q&A to my colleague Linda, who will take some questions from YouTube and others on the platform that are not the Zoom platform. Thank you.
Okay, we are back. Sorry for the hitilafu, but we continue with the questions. And so if you have a question, we have a few people watching on YouTube, so I'm going to take your comments. We also have a few people who had emailed in their questions, so that we'll be able to handle them. There's a question from Stefan Kremer, who says, I hope I pronounce his name right, and he says that why not double opt-in in the first place? It's totally annoying that anyone can bother you with promotional messages where you have to opt out. An opt-in would give an opportunity to consent, and the double opt-in will make sure that only legit emails will be subscribed. So I think that question has come up again, and I think Masi Mutemi as well sent in that same question on opt-in rather than an opt-out. So I'd want to ask from the task force if they would consider that. We have BLA from Nigeria, who's asking on YouTube, hello, can the data regulation going forward help the statistics units acquire international firms such as Google, Facebook, etc., who are based in Kenya, as they have refused to share this data before? We have Hilary Kiboro, who says the regulations provide for mandatory registration of some sectors. Does that imply that for certain sectors, registration is voluntary? Mary Chege asks, would a state parastatal that registers and collects data on licensees be required to be registered as a data controller? Joseph Ishie says, I'm from Nigeria and I would like to inquire whether the regulation is around, whether there's regulation around data localization. Most data held by data controllers for Kenyans, are they stored within Kenya? And then we have Ndungu Muiruri advocates asking, what's the threshold of holding or processing data that will require registration as data processor or data controller? The reference of threshold has been referred to the DPA. We also have Brian Mutai from, I believe KEPSA, who's been asking about the process times and length of getting completely certified as a data processor or controller. He says that this looks prohibitive to go all throughout all these particular processes. We also have Abdul Malik Aden, who asks, will the ODPC consider incentives for SMEs, those with a turnover less than 5 million and below 10 employees that fall under the third schedule, such as fee waivers? There's a final question that I'm gonna read as well. And we have Stefan saying that certification fee is far too high. I believe it's written as 250,000 Kenya shillings. He says a certification under GDPR is £300 for 3 years. So would you be able to answer those particular questions? Sorry, I put them all together in the hope that the task force will be able to pick a few questions to handle. I think DJ Coman is saying on the chat that the Communications Authority has been working on legislation for opt-in already around promotional SMSs. And so I think that's a great comment to talk about. And Ochil Dudley, who is a great lawyer, asks, can a non-natural person complain to the data commissioner under this proposed regulations? And then Tony Nkarichia asks, what of regulation of data given consensually by data subjects in mobile applications such as Facebook, where the data is kept out of Kenya and subsequently breached, which I think Facebook was breached a few weeks ago? What remedies will apply in such a case, and are there procedures in place to detect such breaches? We have over 160 questions, actually 174 questions, so we may not get to all of them at this particular point, but we want to encourage you as well. Next week, there's a public participation forum by the Office of the Data Protection Commissioner. The links will be shared on the chat as well. And if you go to their Twitter page, we also have the links to that particular call. So if you want to let them know, especially what they need to do to amend, to add in, please follow them on Twitter, ODPC_KE. And you can also follow us, Lawyers Hub Kenya. I'd also want to take this, opportunity before Rose comes in to close the questions, and then I think to the task force. I would want to ask for more time. I get WhatsApp messages. Everyone is saying, you see how you rushed through the regulations? We have no time to read. So it took like 5 of us at the Lawyers Hub to read through the regulations and come up with a presentation. And so we want to ask that, is it possible to have a little bit, even 1 more week, for us to be able to go through the regulations? I believe the Lawyers Hub will be able to convene another session, and we want to ask you, if you want to join our data protection working group, can you join on the Lawyers Hub website? You can be a member so that we can be able to discuss these regulations in details and be able to give good feedback to the data commissioner. So we want to ask for 1 more week. If you agree that maybe give us 1 more week, you can let us know in the chat. But Rose is going to come in here and let us know how we can answer the question. So I think I'll go to the to Thuranira to answer one of the questions, and then Rose will take up from there.
Thank you, Linda. Maybe okay, I will not typically answer, but let me elaborate on the direct marketing, because I think what we said earlier may not have gotten. Now, let me give just a literature of what we are provided on direct marketing. Then now you can tell us if we are provided adequately. Now, we are saying that a data controller or a processor may use direct marketing other than sensitive data. So the first thing is you can never use sensitive data for direct marketing. And sensitive personal data includes things like your sexual orientation, marital status, your health status. Never use that. Even if you collect health status, don't send somebody an advert for the medicine. That one is prohibited. Number 2, if you have to use personal data for direct marketing, you must adhere to the following condition. Number 1, it must be that you collected data directly from the data subject. So what you are saying is indirect collection of data. If you collected data indirectly or from publicly available records, don't use those data for direct marketing. You are only allowed to use the one which you collected directly. Number 2, then you have to notify the data subject that the direct marketing is one of the purpose for which you use that data. So that one now, that is what in other words means an opt-in, because opt-in is not a must. We say opt-in, but you can describe. So you have to also tell the data subject during the collection that you'll be using them and you'll be receiving the direct messages. You can put them in that statement. However, even if you say that the data subject must consent to that direct marketing messaging, they have to consent. Then number 2, you have to provide an opt-out mechanism in that any messaging, and then you continue sending that message if the data subject has not opted out. So you have to comply with that tripartite of conditions for it to be a permitted use of commercial data. And as you can see, they are actually somehow stringent if you use them. Some entities may have complied, others may not have complied in that direct marketing messaging. But that's now the condition which is there. So we have opt-out, which as a basis, and we have the opt-in, which is there because, and then also it must be the one you have collected. Maybe the second question, maybe quickly, is somebody has asked if a natural person may lodge a complaint. Now, the Act is generous for launching of a complaint, even though the scope is personal data of a data subject who is living. We don't who is living, because this is a fundamental right. But in the case of lodging complaint, anybody can lodge a complaint. Even a company or an NGO, somebody can lodge a complaint, and the office will handle it accordingly. But those are the response of the 2 issues. Thank you, Leader.
Thank you so much for that. I think there was questions in regards to the pricing. So stating that the price of 250K is too much as opposed to 300 pounds for the UK. Perhaps I'll give that question to Dr. Njogu. But before Dr. Njogu comes in, I will say that these obviously is a public participation forum. The purpose of this was to provide clarity to the regulations that have been put into that have been developed by the task force. We urge you all to make comments and specific comments. So if you go to each regulation and critically look at it, write in your comments detailing what exactly you think should be considered relating to each section, so we can consider it without necessarily having to come back to you to ask what provisions you are referring to. We'd greatly appreciate. We want this to be an inclusive process, and I've taken on board Linda's comments. Perhaps the data commissioner will also respond to that in terms of allocation of extra time for people to consider the draft regulations, and that can be dealt with at the end. Dr. Njogu, if you could please answer that question in regards to the pricing.
Yes, thank you very much, Rose. Regarding these costs for being certified, we have a proposal of 250,000 Kenya shillings. We settled on this figure after we did some local benchmarking and international benchmarking. And in fact, the cost is actually quite low. So based on the findings of the benchmarking, so we're able to set on a 250,000. Now, I think I also need to say that this fee is applicable to those controllers or processors who would want to. Actually, it's a voluntary basis. So once you have to be registered, and you must meet you must comply with that. And should you feel that you want to be certified, just like the way you see with KEBS, they have a golden mark and all that. So we can, the controller, the processor can actually now go to that process of being certified. Of course, there is also some requirements that you have to put, to meet. So that's why we have said, we have a cost of 250,000, and this is not the time that we can be able to classify the controllers or processors, maybe in grade A, grade B, and all that, which I think is a good thing for the controllers and processors, for branding, and again also for marketing themselves in their respective industries. So I think that's quite why we have said we have put that fee. Now, maybe perhaps also, Rose, I can maybe respond to a question somebody asked about MSMEs. Yes, the regulation or the draft regulations have taken care of MSMEs, because we have said anyone who has less than 10 employees and they are making or they have a turnover or revenue of less than 5 million, they don't need to require to register, and especially if they are not providing the services that they were outlined. And again, there is also an aspect that even for the special category of the processing of data, the third level of calculating the fee, we're also going to look at different classes of controllers and processors, so that we are not going to subject all controllers and processors that using the same scale. So I think that has also been taken care of, and I think we're encouraging the MSMEs to participate in this process of getting registered, so that they can benefit from the certification. I think. Yes, I think those are the few comments I wanted to make, Rose. Thank you.
Thank you so much for that, Dr. Njogu. Unfortunately, our time is running out. We have had 178 questions, some of which have been answered, some have not. And these are just the ones on the Zoom platforms, they're not the ones that were shared on YouTube. I guess 2 hours just isn't enough time, but we do have a public participation forum running from the 27th to the 29th. This forum will be run a bit differently to what we're doing now, where we will be reviewing each regulation individually. So on the 27th, we'll do the draft general regulations. The 28th will be the compliance and enforcement regulations, and the 29th will be the registration regulations. The links are up on our Twitter, as well as if you go to odpc.go.ke, you'll also get information in that regard. If any of you have been tweeting, I know that it's a bit late, if you could hashtag data protection KE, as well as tag ODPC_KE, in addition to Lawyers Hub. I don't know whether, I don't have their tag, but I guess it's at Lawyers Hub KE. And just, push this as much as we can. We do want to get as many people participating in this forums. Again, as I said, these are being run very differently to what we're used to. Usually we would have numerous town halls across the county. However, COVID-19 the government's directives will not allow for this. And so we're taking the safer option to do these webinars that we'll be running all of next week. So please participate, as well as please, I can't stress this enough on behalf of the task force members, we want to receive as many comments from you as possible. Please share your written responses specific to the regulations and also specific to the provisions in those regulations that you wish to be addressed so that we can look at it. You're the experts and the practitioners that will need to assist people comply with this regulations, as well as be dealing on a regular basis with this regulation. So it is in your best interest to ensure that you are giving comments. I will now give the floor to our data commissioner, Madam Immaculate Kassait, to make her closing remarks before we close the session for the day.
Thank you, Linda and Rose. We've been listening in to all the comments. I want to just emphasize the level of interest is a demonstration of one, it's the first time we are meeting with stakeholders to discuss matters data protection regulation. So that gap in the long run will be addressed by what we are creating awareness, because some of the questions you can see there's need for awareness creation to basically unpack what is the Data Protection Act. So that is a commitment from our office. It's a task that this task force has been given, resources allowing, and with mobilization with stakeholders like the Lawyers Hub, that this is what we are going to do. Apart from the regulations, just disseminating information, we'll also have an opportunity to create awareness. Two is what the question that I wanted to also clarify on the issue of registration. We've adopted two approaches. One is what we call the big bang on the general regulation and enforcement. Once the regulations are gazetted, they come into force. However, on the registration, the registration will come to force once a notice has been issued by the Office of the Data Commissioner. Three is the issue about ADR, Alternative Dispute Resolution. If you look at the Data Protection Act, it's one of the issues that has been emphasized. It is one of the issues that the office would like to embrace in terms of alternative dispute resolution. It is provided for, and the mechanism is what we have attempted to provide for that in the regulations. Tell us whether that is adequate or there are areas that you'd like us to improve. On issues around administrative compliance, this is an area we will certainly be able to give additional guidelines, because when it comes to compliance, we may not be able to put every single detail in the regulations, but like has been provided, and if you saw in my way forward, we say, apart from the regulation, we'll also embark on sector-specific regulation after these ones, and also guidelines. The guidelines should be able to address some of those concerns. Are the forms adequate? Are they not adequate? What can we modify? What can you not modify? But in terms of priority, the priority was to try and get these regulations out so that we are able to begin we are able to enhance implementation of the Data Protection Act. There was a question about complication of the process of registration. You will be guided by a service charter, which we launched at the 100 days, where we are saying when it comes to the registration, which is supposed to be automated, you're supposed to apply online. We will then we will be able to complete the process within 30 days. For compliance, an investigation that is supposed to be done within the 90 days. That are issues we have addressed in the service charter, and they are issues that we should be able to share with you in due course. There are many, many questions on these particular issues in terms of adequacy. We may not be able to address all of them now, but we look at them, and like Rose has emphasized, please share with us the specific parts of the regulations you'd like us to relook at. I have had the request on additional time. We are also equally pressed for time. If you look at the calendar of Parliament, because we want to make sure that this is addressed before they go on recess on the next financial year, because it also has an implication in terms of people doing business and dealing with the issue of anxiety. However, we've had the request, Linda. It's something we'll take back to the task force and then revert back to you in as far as the additional time. If it's possible, we will let you know. Thank you for this session, and we really do appreciate it. Yes.
Thank you. Thank you so much, Commissioner. We sincerely appreciate, the support. We feel heard, we feel that, we have the opportunity to engage. And I know a lot of us have been sending messages and emails and wondering how they could, interface with your office. I think I want to admit at this point that this is the best public participation exercise we've ever had, because mostly we're at loggerheads, people are not talking to each other. We don't want to go for their forum, they don't want to come for ours, but we see the advantage of working together and actually listening to each other, both sides of the divide. So we really thank you for this. And we also love the sector-specific approach that you've taken to talk to the academics. Today, I think there was a session with the universities as well. I think this is the next level of public participation. And we need to do this and figure out how we get it to mashinani so people can actually join virtually, from their local centers in that sense. But we really want to thank you so much. And we look forward to joining the session next week. We also just want to plead again for time. If there's anything else, we just want time to really analyze, do some comparisons with other countries, and also look at the impact that this will have on the sector, because we don't want eventually to have people actually running away from data protection law. They can start, black market for data, because sometimes the law does not envision that, unintended consequences in that sense. So we just want to ask for more time if it's possible, and we'll be able to make our submissions. But thank you very much. And thanks, Rose, as well, for the good work and, the close collaboration that we've had together. This took like 3 days or 4 to put together, and it's come out very, very nicely. So thank you, Commissioner. We appreciate.
Yeah, and just to mention, we will be having a session with the county governments and the assembly forums next week. We hope to mobilize as many as possible so that they're also able to attend. It's important that they also appreciate data protection. Thank you.
Thank you very much. We look forward to that as well. We have Laikipia County that comes for some of our sessions here with the ICT departments and Kisumu. So we hope that you have had that. Thank you. I think there's something that I was forgetting that I'm being reminded about. Okay, so people are asking about the chats and the questions. We're going to put them all together. If you're looking to watch the recording, please go on YouTube. It's live on YouTube, Lawyers Hub Kenya. And I hear that Kenyans don't subscribe to pages out of, I don't know whether it's jealousy or what. Please, for heaven's sake, today, go and like our page. That way, the algorithm gives us an opportunity for other people who don't know about this page to see the content. If you go on Twitter as well, please go to the ODPC_KE, follow them on Twitter, then put on notifications. That way, when they tweet, you are made aware. Also go to Lawyers Hub Kenya, put on notifications. That way you'll be able to get this particular information. Please don't subscribe to social media. Those people, you watch stuff you don't want to say in public, but you can't look for such good content. So please follow these particular accounts, and we hope we'll be chatting in the near future. Next Monday is World Intellectual Property Day. And so we'll be having a session on commercialization of intellectual property together with different partners, including the Kenya National Innovation Agency. We also have the Kenya Copyright Board. We have Riara Law School. We'll be running this together next week on Monday. So we want to urge you, the same link, the link doesn't change. So if you want to join next week, just click the button and join us at 2 p.m. I think that's it. Thomas Louis, thanks for saying
before I forget, let's thank the PS Jerome for staying in. He's still there. We really do thank him for staying in and listening in to our conversation. Thank you, Bwana PS.
Thank you so much, PS. And I am sorry, I'm really bad with protocol. So you will forgive me. I don't know that Bwana PS wants to say something. I don't know who comes first after I have spoken. Rose told me I can't speak after my boss. I said, okay, I speak anytime I want.
No, it's okay. We can end. Okay. It's fine. At least, yes.
All right then. Thanks everyone, and thanks for joining us. I hope you have a lovely week. I hope that you keep safe. Please observe the curfew timelines. We need to be rushing home already. Please don't stay on until it's too late. And we hope to see you next week on Monday. Intellectual property and how to commercialize it. So any startups in the room, the lawyers, please join us as we celebrate Intellectual Property Day. Have a good one. Bye-bye.